Thanks for joining us today. Today we're talking about international planning, and specifically we'll be discussing international wills. We do this podcast once a week and discuss estate planning, legacy planning, everything related to leaving a legacy and how you want to be remembered after you're gone. One of the things that comes up frequently when we meet with clients is we find people who have international assets that they either own in another country, or maybe a family member has left in another country, and we want to make sure that those assets are not forgotten about. Sometimes, I have a client of mine that's from Mexico, and they had a property in the actual capital city. And back when they received it, it was inherited from their parents. It was kind of on the outskirts of the city, and it wasn't worth a whole lot. Since then, the city has grown a lot, and its urban sprawl has eaten up that area, and so now it's worth quite a bit. Unfortunately, when they inherited the property, they never transferred title properly to them, and so over the years, they've had to fight off different family members that tried to claim that the property was supposed to go to them, that they've been living in the property for years and years, and so therefore it's theirs, and other issues like that. And they've been able to successfully, keep control over the property up until this point. But their children don't have any connections to Mexico. They don't even speak Spanish. So how are their children going to then maneuver and be able to do what needs to be done to transfer title when they're gone if they don't leave a proper plan? And even, claiming their interest because it hasn't been properly transferred could be very difficult for the children because they don't have the paperwork and the information necessary to accomplish that. So a lot of times we imagine that, keeping track of what's ours is not that difficult, and that we can make sure that the family's going to get it without having to do much. The reality is that if you don't put a plan in place, if you don't put documents in place and empower your loved ones to be able to keep track of those assets, especially international assets, it can really cause problems and issues down the road. So the intention of international planning is to put documents in place that can be honored in whatever jurisdiction you own property. Sometimes the property is here in the United States, and there may be international issues, which we'll discuss at a later point, for foreign nationals or for others that have property here in the United States. But sometimes the property is abroad in other countries. And in order to properly protect that property, especially real estate, it's subject to the laws of the country where it's located. So wherever that property is located, the laws of that country are going to determine how the property actually gets distributed, who can receive it, under what guidelines, and so on and so forth. So the idea of the international will is really for the purpose of convenience of planning here in the United States. And for some countries, it will automatically be valid and honored and act just like a legal document within that country. The reason for this is because there's a UNIDROIT tax treaty, which basically means that, under the United Nations, there's a division of the United Nations dedicated to, communications between countries. And one of the discussions that they've had is about trying to make estate planning more uniform for the international community. And so 32 countries or so signed on to a treaty that basically said, if wills comply with these requirements, then we will honor them as if they were created under the laws of our country. And those signatory states will all accept an international will that meets certain requirements. And those requirements are very easy to meet. They're pretty standard, especially here in the United States. The will has to, be in writing and comply with standard sort of provisions that state who's going to be in charge and how a property is divided. And then the requirements that have to be met basically is that you have 2 independent witnesses. It has to be notarized, under the laws of the jurisdiction where it's created. It has to comply substantially with the laws of that jurisdiction. And it has to have a special international certification that goes along with the will. So really, that's the only requirement for your will to comply with the international treaty for wills. But one of the things that we also find is that it's very important to make sure that if you do have property abroad, that your will doesn't purport to overreach or to interfere with any planning that you may have in those countries, especially as it relates to real estate. So if you have a home in the Philippines is a country that does not recognize a U.S.-based trust. You can't just put that home into your U.S.-based estate plan. You would have to have a will under the law of the Philippines. And that will would likely say, okay, well, my property in the Philippines is going to be divided like this. But one of the standard provisions in most estate plans and most wills that you would do is that it's going to terminate any other will that you've completed. So if you come to the United States after doing your Filipino will, and then you do a U.S.-based will, and it says there that all other wills are removed and terminated, they don't have any validity, what happens to your international Filipino will that you just created? It's possible that it could also be invalidated. And so one of the things that's important to envision within your international will, if you do an international will or if you do planning in multiple countries, is that you want your documents to coordinate. So your international will should say, as to my property in the United States, this is what I want to have happen. As to my property in the Philippines, this is what I want to have happen. And that sort of coordination, that foresight, helps to avoid a lot of problems in their interpretation of documents, and especially if it ends up in an international court. It shows foresight. It shows that you intended specifically for something to happen with that property or something to happen with your estate that was foreseen beforehand, and it's much easier for the court to enforce those sort of provisions. So we always recommend, if you're doing international planning, that whoever is doing your planning abroad in other countries coordinates those documents with your legal counsel here in the United States. And if you coordinate those documents, then there shouldn't be any problem with making sure that they're both going to be honored in their respective areas. The other thing to keep in mind when you do an international will is that if a country is not a signatory state to the International Will Treaty, then your international will may or may not be able to be probated in that country. It's possible that it will be, and it's very likely that it will be, but having something is better than having nothing, right? If you don't have a will or a trust or a plan that conforms with the specific country where you have real estate assets, and I keep saying real estate because real property is the hardest thing to get away from the jurisdiction where it's located. Other assets we might be able to situs in the United States a lot easier. But real property is subject to the laws of the location where it's at. And so, having some sort of document in writing that can be perhaps translated, perhaps, brought to the court for consideration is going to put you in a much stronger position if you ever do need to go through an international probate than having nothing. And if you have an international will, then the likelihood is that will be considered by any court in any country, at least as persuasive evidence, if not controlling evidence. Whereas if you simply have a U.S. document, it may be completely disregarded. If you do not have any documents, then you'll be subject to the laws of intestacy. And one of the things to remember is that in some countries, intestacy is actually not that bad. For example, if you're in India and you have property and you leave property, the transfer of that property on an informal basis is actually very easy, as long as it's going, to the family members, the way that Indian law basically lays things out. In other countries, probate can be extremely difficult. We had a client recently that we were working with, and they from a country in the Middle East. And this particular country, the legal system there is functional, but it's very difficult to be able to coordinate or get a hold of from outside of the country. It's not a country that's extremely friendly with the United States, and so it's very difficult to be able to really do anything in regards to the property transfers from outside of the country. So in order to handle those sort of situations, because we do handle a lot of international property transfers and so on, we needed to find a local counsel and basically have them do everything, because there was nothing that we could really do from our side of the fence. So again, international planning is one of those things that anytime that you have an asset that would fall under those parameters, sometimes clients or individuals will say, well, it's not a big deal. I only have a small house in Greece. It's only worth $150,000. Yes, but are you okay with losing it? Are you okay with it not transferring to your family? Because if you don't plan for it, it likely will be lost. We had a client that we sat down with, and they had property in multiple countries. They had a vacation home in Central America, and they had a beach house in Brazil. And they said, well, it's not a really big deal. They had just gone through a divorce, and those were some of the properties, the assets that they had kept from the divorce proceedings. But they said, it's not really a big deal. I don't know if I really even want to leave it for the kids or anything else. But if they don't do a plan and they don't leave it properly for the next generation, then it will likely be lost. And then the question is, well, what happens with it? In some countries, you got to keep in mind that, property taxes don't just stop when you die. Somebody's going to be responsible for that. And so, if nobody is maintaining the property and it just gets foreclosed on, in a lot of these countries, there's no mortgages on the property because it's so inexpensive to be able to purchase it. You wouldn't have a mortgage. So it's not going to get foreclosed per se. But the government may foreclose on it because of unpaid property taxes. Or you could be liable, your family could be liable if something happens there. So just imagine, and I'm not saying that this would ever happen, but just imagine this beach house is left and it doesn't transfer to anyone. All of a sudden somebody gets murdered there, right? And then they're trying to sue the owner for not having a proper premises or protection, or maybe they, left something dangerous there. And the family all of a sudden has to deal with that sort of thing because that's who it rolls down to, even though they haven't received the interest. That doesn't stop them from having to defend themselves. So, just things to consider, things to think about. If you have international assets of any kind, we recommend that you sit down with competent legal counsel. They're going to be able to advise you on how to transfer those assets, whether it's before you pass away or whether it's part of your estate plan. If you need to set up an international will, or if you need to set up documents in another country outside of the United States, work with competent legal counsel in that country to be able to do those documents, or work with somebody here that can help you coordinate with competent legal counsel to make sure that that's put in place for you. And then to the extent that we can do things on an international basis with international documents, then I think that's a great way to go, because then you have one professional helping you with all of your planning here in the United States and coordinating those documents on an international basis without having to bring in multiple parties and, different perspectives. So I think the best thing that I could advise is, if you have international real estate in particular, strongly consider doing some international planning and having specific documents to that effect. If you have just bank accounts or other sort of assets that are not real estate, Many times those assets can be transferred into your U.S.-based estate plan, and that's how we would recommend doing it, whether by beneficiary designations or whether by having your trust or your estate plan actually own the assets in that country. And if it's not real estate, then it should be able to function that way without any problems. So again, depending on the country we're dealing with, every country has different laws, every country has different regulations, and sometimes making sure that you have local documents are extremely important. Sometimes we can work around international documents, and sometimes we can work with U.S.-based documents, and every situation is going to be a little bit different. So we recommend that you sit down with somebody who can provide you with good guidance and good insights for your specific situation. And hopefully that will be our team. So if you're listening to this podcast, we do have recorded podcasts from previous weeks, and they're on YouTube. They're on, wherever you get your podcasts. Feel free to subscribe. We'd love to have you continue to join in. Next week, we'll be covering a little bit more in depth in regards to legacy planning. And for today, if we have any questions or anybody's in the room, feel free to raise your hand and we can see if we can unmute you so that you can ask your question. All right, we did have a question that was submitted, and the question is this. If you have a spouse that does not live in the United States, and they have property abroad, but all of your property is here, do you need to worry about having an international plan? And that's a great question. Whether it's a spouse, whether it's another family member, whatever they own is likely going to be held in their personal name and subject to the law of the country where it's located, to those laws. Now, some countries have similar sort of laws to community property states here in the United States, where everything that's considered to be owned by both spouses. Most countries don't. Most countries consider whoever owns the property, that's the property owner that would need to do planning or have documents in place in order for it to transfer to anyone else. So I mentioned the property earlier that was in the Middle East, right? It's actually in Yemen. In Yemen, the husband owned all the property. His wife survives him. He passed away. She didn't automatically receive that property because there's no community property type of statutes in Yemen, right? So in order for it to transfer, somebody needs to go and do the actual title transfer of the assets in Yemen. So don't assume that between spouses, you're going to be able to have things transfer without any problems. That's the first thing. The second thing is there may not be a need for your spouse in that situation, if they're a foreign national, to have a U.S.-based estate plan. And there may not be a need for you to have an international estate plan, but there will be a need for your spouse to have a foreign estate plan in that country. And for you, if you own property here in the U.S., to have a U.S.-based estate plan. So again, meet with somebody who could provide you with some specific guidance as to your situation. But that's in general terms, that's what we would say is, husband might need to have a plan in China or in whatever country he's located. And the wife might need to have a plan here in the United States. And then those plans should coordinate to the extent that they're going to involve the same individuals. All right. Well, thanks again for joining us. We're going to go ahead and wrap up this call. Appreciate everybody signing in, and everybody who is interested in following us. Make sure that you subscribe or that you follow us wherever you get your podcasts.